Hello, my name is Megan Jones. I'm the State Director of the Florida YMCA Youth and Government Program, and welcome to Judicial.
Hi, my name is Kameron Weidner. I'm the Judicial Graduate Advisor, and today we're here at the Supreme Court, where appellate hearings are heard for the state.
At State Assembly, you'll be here at the Capitol Complex arguing constitutionality for the District and Supreme Courts. But there's a lot to do before we get to that point, and we're here to help you every step of the way. Welcome to Judicial.
In both our District and Supreme Courts, you will be an attorney in an appellate court, not a trial court. What this means is that you are not going to be arguing about whether someone is guilty or not, or the facts of the case. You just need to determine whether the ruling of the lower court needs to be overturned or upheld. The important thing that you can do first throughout the year is to read the case provided. These cases are written by the presiding officers and consist of the facts and court proceedings. Specifically, in the Supreme Court, you are also provided with the lower court's decision. As an attorney, you will represent the petitioner or the respondent. In district court, you will argue for the side that you are assigned. In the Supreme Court, you will argue for both the petitioner and the respondent. As the petitioner, you are challenging the ruling of the lower court, and you want their decision to be reversed. As the respondent, you are arguing in favor of the lower court's decision and want their decision to be upheld. In the district court, individually throughout the year, you will write a memo on the side that you are assigned. A memo consists of 5 parts. First being the question. This is the issue in the case. Second is a brief answer to the question. This is where you will outline whether or not the issue in the case is constitutional. Third is the facts of the case. This is where you'll present all previous proceedings and facts of the case. Next is the discussion. This is where you will outline all your precedent. We'll talk about that later. Finally is the conclusion. This is where you will connect all the dots of your memo and make a decision. Is the issue in the case constitutional? In the Supreme Court, throughout the year, you will work in your firm to draft a brief for both the petitioner and the respondent. Here are the different parts of a brief. Take note of the table of authorities. This is where you will list all of your precedent. Also look at the argument section. This is how you apply your precedent to your arguments in the case. All formatting guides for briefs and memos can be found in the resource directory. Precedent is what you use to support your argument. There are 2 types of precedent, binding and persuasive. In Florida, binding precedent consists of the decisions of all Florida appeals courts, the Florida Supreme Court, and the Federal Supreme Court. An example of persuasive precedent is a Supreme Court ruling from another state. Be careful not to form your entire argument based off of persuasive precedent because it doesn't have as much weight as binding. Ways to find precedent include using platforms such as Google Scholar to research case law. There's a setting wheel to filter through just federal courts and Florida courts. For example, you can research an issue such as Miranda rights, and a multitude of cases will pop up. You can read through these cases and their decisions and see if they support your argument. Another website you can use to research Florida statute is this website, also known as Online Sunshine.